I understand Dr. Christoph Schroeder is now on the phone, correct?
That's correct. Hello, everybody. And sorry for having trouble dialing in.
No problem. We just knocked off an agenda item while we were taking care of those technical aspects. Dr. Schroeder is a member of the CMS, and I'm probably going to butcher this name, so correct me, Haschel Sigel law firm. Is that right?
Haschel Ziegler, yes.
Okay. And forgive me, although I have a German last name, my German pronunciation is atrocious. Christoph is a member of the firm's Hamburg-based Maritime practice, although I understand you're resident in the Singapore office, and I met you in China last fall, right?
Yes, I'm based in Shanghai, yes. And
I'm sorry,
we met
Shanghai.
in Hangzhou, which is almost a neighboring city.
You've been advising maritime companies on a wide range of legal aspects in respective businesses, including cargo claims, ship collisions, arrested vessels, and agreements like shipbuilding contracts, charter parties, bills of lading, and other things. You have extensive experience in European courts, and you completed your doctoral work in law in China, currently based in the Shanghai office. And I had the great benefit of seeing Christoph speak in China at the World Congress of Ocean last September, and I was extremely impressed with what he had to say and the advice he had about the recent changes to the German maritime law. So we asked him to come and speak to us today. And with that, Christoph, I'll turn it over to you. Noting before I do, everybody, that I sent around an email yesterday with a link to a PowerPoint presentation. If you have any trouble getting that, shoot me an email now, and I can ping you a PDF copy quickly. Otherwise, you could just follow along from the link. And Christoph, I'd ask that as you flip through the pages, just let us know when to switch to the next slide. And with that, okay. I'll turn it over.
Okay. Thank you, first of all, James, for your invitation and for preparing this call. And it's a great pleasure for me to talk to you today. I hope everyone has this PowerPoint presentation before you or themselves, and this will give you a basic structure of the discussion. James urged me to stop talking after 20 minutes, and I will try my best to finish in time. That said, please always feel free to interrupt me, because that will hopefully wake everybody up and will also show me that the connection is still working. So whenever you have a question, please feel free to raise it immediately. So I'm now virtually turning to page 2 of the presentation with the headline Entry into Force and Sources of Law Affected. Well, maybe I should say a few general words. Basically, this is the time for maritime lawyers in Germany to make presentations, because only maybe every 20 years will there be such a reform of maritime law, at least in our country. And so this was really a chance to make a fundamental and very basic reform, and in my view, it was done very well, and I will guide you through some of those amendments now. This reform entered into force on 25th of April 2013, so we are almost in the second year now of the reform. We have not seen any crucial judgment on the reformed part of the law yet. That is still a little bit too early. There are a couple of very quick district courts, especially in Hamburg, but I guess we will still have to wait a couple of months until the first decisions will be made on issues that relate to the amended part of the law. What has changed already are bill of lading terms and conditions of German ocean carriers and NVOCCs, whose terms are governed by German law. We had the pleasure of being mandated to amend some of them, and this, as we see, has now already, with all of them, been put in place. So everyone's basically ready to operate under the new law, and but this is in fact apart maybe from arrests, which I will talk about later, is maybe the only change that has been brought about so far, the only visible change. There's one technical thing I should not forget. In order to determine whether to apply old or new law, it is crucial when the respective obligation was created, and usually, as we mainly talk about contracts, that will be the date when the contract was made. So if that date of the contract was before 25th of April 2013, old law would apply, and otherwise new law. Germany did not make any amendments relating to international conventions. That means Germany did not revoke the Hague Rules. It is a member state of the Hague Rules, and that will stay the same. Germany never ratified the Hague-Visby Rules, or the Visby Protocol, and that will stay the same. And as far as Rotterdam rules are concerned, they will not be ratified by Germany until other major shipping nations take the same step. And we would expect that this will take at least another couple of years if the Rotterdam rules will enter into force at all. So that was also one reason why Germany moved ahead with the reform and made some amendments to its national law, and that means that in particular the commercial code was amended, and there again in particular Book 5, Maritime Trade. And then there were a couple of other laws affected, in particular the Code of Civil Procedure, and there in particular relating to the arrest. But this is basically what was amended, and the result is that despite many criticisms from many sides and angles during the process of the reform, that German law is in effect essentially still in line with international standards. I now turn over to page 3 of the presentation, and I will now take you quickly through the new structure of Book 5 called Maritime Trade of the German Commercial Code. This is essentially where German maritime law is based, as far as lawyers are interested to see. So there are a couple of chapters. First chapter being persons in shipping. Next chapter is contracts of carriage. And there we have 2 sub-chapters. One is contracts for the carriage of goods by sea, and the other is passenger carriage contracts. And then it goes on a little bit more into details. We have a title called Contracts for the Carriage of General Cargo, and another title, Voyage Charter Contracts. And within the contracts for the carriage of general cargo, we have general provisions. We have the good old liability for loss or damage to cargo, and some provisions on transport documents, in particular, of course, bill of ladings and seaway bills. I turn over to page 4 now. We have another chapter that relates to charter parties with subchapters on bareboat and time charters. Then we have a special chapter that could be called Ships Emergencies, as it contains 3 subchapters on collision, on salvage, and on general average. I turn over to the next page, page 5 now. There are 4 more chapters, and then we are done with the overview. Ship creditors is one, then some provisions on the limitation period, then the general limitation of liability as opposed to the limitation of liability under contracts of affreightment, and last not least, some procedural rules also in the commercial code. As a result, once you have made yourself familiar with that structure, you will find that this is a fairly easily accessible structure, even for professionals who are not familiar with maritime law, and it is a clear improvement as far as language and wording and structure of the law is concerned. So it's rather easy to find the relevant provisions now, and that is clearly an advantage of this reform. I turn over to the next page, which is page 6, and I will now introduce to you some details of the reform. The first one being the chapter Persons in Shipping. Persons in shipping are defined in this chapter, and there are some special provisions that should be paid attention to. Who are persons in shipping? We're talking about owners, about temporary owners, about the crew and the master. I'm going to go into some details later on, especially as far as temporary owners are concerned, but let me go on to say that especially in this part of the law, there was a considerable cut in the number of provisions, and several concepts were abolished, 2 of them being so-called shipping partnerships, which was a special legal form of companies, and also abolished was the so-called sea protest, which might sound familiar to you. We thought that those 2 concepts were not only outdated but also practically irrelevant. You could almost say that they were dead law. So these were abolished, and the provisions regarding the master's legal position were greatly reformed to now reflect the change in the position of the master from an entrepreneur to an employee. So that was quite a major change. And one thing that I think is especially interesting for practitioners is the definition of the temporary owner and also the further provisions. A temporary owner is a person who operates a vessel which does not belong to him for maritime trade, and the typical example of a so-called temporary owner is the bareboat charterer. Now, what is the implication of this? The so-called temporary owner is vis-à-vis third parties the only one to be regarded as the owner, which means that whenever you have a claim which you want to bring against the owner of the vessel, you should always, if you know, sue the temporary owner, or in the typical example, the bareboat charterer, as he will be the one assuming all liability of the ship owner. But as some of you will know, it was or has been in practice very, very difficult or almost impossible for third parties to find out whether the vessel was actually bareboat chartered or not. So third parties had to turn their guns to the registered owners, and were then often told that the vessel was bareboat chartered. This was quite a difficult situation, and so Germany reacted and said, if the claim, if a third-party claim is brought against the registered owner, and if he then does not immediately nominate temporary owners or bareboat charterers, if any, then that registered owner will be liable for and assume all liability as a ship owner. So that is a clear facilitation for third parties bringing claims against ship owners. So next is now page 7 of the presentation. Generally speaking, and please correct me if I'm wrong, it used to be a very popular means to force your contractual partners to the negotiating table when you had the chance to apply for a Rule B attachment in the United States, especially in New York. But that, as far as I know, has virtually come to an end, and I think it was October 2009 when that practice actually came to a standstill, which then in turn made the arrest of vessels more popular, because that was to a certain extent then the only possible way to quickly get people to negotiating about a certain claim if the requirements were met for such arrest. So the question is Germany now a location which can be considered as a very good and easy place to arrest vessels? At least previously, before the reform, that was clearly not the case, because there were two major requirements for an arrest, not only an arrest of a vessel, but also generally. You had to present to the court a so-called arrest claim. That is the claim, the actual claim which you bring against the other party. So you had to give some sort of evidence, not formally, but you had to have convincing evidence and show documents that actually show that you have a maritime claim. But then there was another requirement also for the arrest of vessels, and that was that the claimant had to show that there's a risk that without such arrest, a judgment following the main action would not be executed or substantially impeded. So you had to show that you would otherwise have difficulties in executing a judgment made in your favor, and that second requirement has now been abolished, So the only thing that needs to be done basically is that you hand in documents on which you base your claim. That said, you could believe that it's now easy to arrest a vessel in Germany, but there are a couple of howevers which I also have to bring to your attention. One of them being that this abolishment of that second requirement only relates to vessels themselves and not to other assets on the vessel, for example, bunkers, which could also sometimes be the object of an arrest. It is also noteworthy that an arrest of vessel is not eligible to secure claims against other debtors than the owners of the vessel, for example, claims against time charterers. And the court, in our experience, may and will request the applicant to provide security. The court has discretion in this respect, so the court may also not request any security, but our recent experience is that the courts have not they have not dropped this requirement, and usually they would ask for a bank guarantee in the amount of that claim that is made against the owner of the vessel. And then there's another rather high threshold that needs to be overcome, and that is you must be, as a claimant, as an arrest claimant, you must be very, very sure that your claim actually exists, because there's a vicarious liability for wrongful arrest, which does not exist in other jurisdictions, for example, in the Netherlands or in Belgium. So to sum this up, Germany does provide for improved and easier requirements to arrest a vessel, but it's still not considered to be the number one location in Europe to get the vessel into the chain. So I would always recommend to follow and track any vessel of the opposing side, maybe on marinetraffic.com or other sources, and then see whether there's a port in a jurisdiction which is maybe a little bit easier. But nevertheless, it's not impossible, and if you have a case like this, it will be easy to check your chances. I turn over to the next page. It's page 8. There were some amendments with respect to the exclusions of the carrier's liability. As you probably all know, the usual thing under Hague and Hague-Visby rules is that there is a exclusion of liability for loss or damage that can be related to an error in navigation or to fire, and that exclusion of liability is one that is provided at law, so it does not have to be agreed upon. Germany has now abolished this, and there's no such exclusions in the law anymore. However, since Germany did not revoke the Hague rules, in some of the, I would call them Hague rules situations, the carrier can still enjoy those two exclusions of liability at law, and what is even more important, parties can agree on such exclusions, so that would be valid, and even by way of general terms and conditions. I emphasize this here because German law relating to general terms and conditions is rather strict. The courts do not allow the parties to be very free in drafting general terms and conditions. So you may guess what was inserted into Bill of Lading terms of German ocean carriers recently. I turn over to page 9. Just a few words about the new concept of a performing carrier, or you could also say actual carrier. That was also a concept which was much discussed under Rotterdam rules. Like before, cargo claimants can choose to sue only or also the performing carrier, which means the contractual carrier and the actual or performing carrier, they are jointly and severally liable for cargo losses and damages. What is a performing carrier? The German law does not define this term. One would expect that it's something like any third party who wholly or partly performs the transport which the carrier is obliged to perform. But the question is, will terminal operators and stevedores fall under this scope or not? This is something case law needs to decide, and we are waiting for the first judgment, as I said earlier. What is new under this concept is that the performing carrier is now liable to the same extent as the contractual carrier, so there's a complete parallel in liability. Now it's time for the last page, page 10. Let me just give you a short overview on limitation of time. The periods for limitation of time are now stipulated in 2 subsequent provisions, which is nice and easy to see and grasp. The limitation of time is either 1 year or 2 years, depending on the nature of the claim, as far as cargo claims are concerned, and also claims for contribution in general average. For example, we have a 1 year time limitation. What has become easier for cargo claimants now is to suspend limitation of time. Before the reform entered into force, it was necessary to actually bring a lawsuit against the carrier if he neither said that or agreed on an extension of time, or there were any negotiations. That's the second bullet point there. So you had to bring a lawsuit. That is now not required anymore. You can, by holding the carrier liable in text form, and that means fax and email are sufficient, you can suspend the limitation of time. However, the carrier can react and reject such text form holding liable, also in text form, and then limitation of time will continue to count. It is not possible to deviate from the law in this respect by way of general terms and conditions, and that applies especially to contracts for the carriage of general cargo and bills of lading. This was a short overview on, in my view, the most relevant, especially for practitioners, relevant amendments to the German law. And if you have any questions either now or after the call, then I would be happy to answer them. Thank you.
This is, again, Jim Colzer. Christoph, thank you so much. I think you covered a lot of ground in a very short amount of time, and I very much appreciate it. And I forgot to mention before you started, it is 1:30 in the morning your time. Is that right?
Now it's 1:10.
Now it's 1. Okay. Well, thanks for staying up so late
Yes.
to get this done. You must have had a lot of
No
coffee
problem.
today. Let me open it up. Does anybody have questions?
Hey, Jim, it's Chris Nolan. I just have one for him. You know, when we're looking at that area of the world, usually Rotterdam is the easiest place to arrest. And I'm wondering, did the Germans decide to revise the rules to make it as a venue to counter Rotterdam? It doesn't. I mean, it can't. I don't think it probably could be as easy as it is in Rotterdam. But you know, what was that the purpose, Christoph?
Very good question. I would clearly say no. Although it looks in the first place as if Germany copied some rules that apply in Rotterdam, but there are so many buts and howevers, which I pointed out earlier, that could not have been the serious intention of the German legislator, because otherwise they would have had to also drop this vicarious liability, for example, or would have had to limit the chances for the court to ask for security. So I think, in essence, that was not the intention. But again, Rotterdam was taken into account, at least.
Fair enough. Thanks, Christoph.
Anybody else have a question? I've got one.
Chris?
Go ahead.
Chris, it's David Deal. It's not a question, but it's a comment. We have the Boca Raton ABA TIPS meeting coming up. I want to thank you, Chris, for arranging for Bob Kirk to be there for Carnival Cruise Lines, and also a Marriott Vice President of Corporate Counsel. There's going to be a resort tours seminar, which includes some maritime admiralty topics as it relates mainly to cruise ship passengers. And the resort is a fantastic place. The rates are very reasonable, and I hope everybody will spread the word and come and see this great seminar and enjoy yourselves in Florida for the spring meeting.
Hey, David, that's nice. I think that Jim is probably going to get to a little later once he lets Christoph go to sleep.
Okay, sorry.
Am I right?
Don't worry.
Run on to something else.
Yeah.
Thanks, Dave. Christoph, I had a question.
Nice presentation. Thank you, Christoph.
It was a pleasure.
You mentioned that third-party claims against ship owners, they need to nominate a temporary owner, otherwise the claim would lie against the registered owner. I'm curious, do you know how that's affecting the insurance industry? How are insurers accommodating that change in the law, if you know?
I'm not aware that they made any essential amendments to their insurance terms and conditions, to be honest. At this moment, I think. Well, actually, it is. I would say, of course, there is a higher liability risk with registered owners. That's true, and they have to react quite quickly. To be honest, I'm not aware of any amendments and how they reacted. I would have to do some research on that or ask some clients.
No, that's okay. Another question I had is, you mentioned the general limitation of liability standard. Can you tell us in general terms what sort of general limitation of liability provisions you have in German law now?
You mean the global limitation of liability, right? Not
opposed
the one
to something
relating to loss of cargo, right?
Correct.
Okay. Germany is a contract or member state of both those limitation of liability conventions. As Germany is also the member state of that second convention, I think that's 1999 or 1996 convention, the higher standards apply. So there's no specific amendments. Germany is just a member state and will comply with those rules.
Great. Thank you.
Christoph, the temporary owner provision in Germany, when there's like a bare bones charter, does that temporary owner have the ability to limit their liability to the value of the vessel in claims involving the operation of the vessel?
Yes, that is possible.
Okay.
Because he would enjoy the limitations of liability under the convention.
Okay. I have to drop off, everybody. Nice job. Take care. And thanks again, Chris and Jim and Christoph. Bye-bye.
Goodbye.
Any other questions for Christoph? Okay. Well, thanks again. We really appreciate it. And we appreciate all the time and effort you put into this, and we especially appreciate you staying up late so that you could give us the conference call at our normal time.
No problem. Again, great pleasure.
Thank you.